As we have a quorum of 4 members, I now wish to call the meeting to order. Apologies have been received from Senator Paddy Coffey and Senator Grace O'Sullivan. At the outset, I remind members, staff, witnesses and those in the public gallery to turn off their mobile phones. So you might take a moment to check those, please. I now wish to read some formal notices for the information of the witnesses. I wish to draw your attention to the fact that by virtue of Section 17(2)(l) of the Defamation Act 2009, witnesses are protected by absolute privilege in respect of their evidence to this committee. However, if you are directed by the Chairman to cease giving evidence in relation to a particular matter and you continue to do so, you are entitled thereafter only to a qualified privilege in respect of your evidence. You are directed that only evidence connected with the subject matter of this proceedings is to be given, and you are asked to respect the parliamentary practice to the effect that, where possible, you should not criticise nor make charges against any persons or entity by name or in such a way as to make him, her or it identifiable. Members are reminded of the long-standing parliamentary practice to the effect that they should not comment on, criticise or make charges against a person outside the Houses or an official either by name or in such a way to make him or her identifiable. On behalf of the committee, I would like to welcome the following witnesses to the meeting today. Mr Seán Canney, who is a concerned member of the public who has called for a change to the law regulating abandoned safety deposits in banks. Officials from the Department of Rural and Community Development, Mr Kenneth Jordan, Principal, and Mr Stephen Brady, Assistant Principal from the Finance and Evaluation Unit. Officials from the Department of Finance, Mr Owen Dorgan, Principal, Central Bank, NTMA and Financial Stability Policy, and Ms Fidel McCotter, Assistant Principal, Banking Division. I would also like to thank the bodies who wrote to the committee with their advice and observations. Deputy Seán Canney, or Seán Canney, who's a former Minister at the Department of Rural and Community Development. I'd like to thank him for making an observation on this particular issue. The Department of Justice and Equality, the Banking and Payments Federation of Ireland as well. It's proposed that any opening statements or submissions or other documents supplied by witnesses or other bodies to the committee relating to the topic of this meeting be published on the committee's website. Is that agreed? Agreed. I now call on Mr Seán Canney to make his opening statement.
Thank you. Thank you for the opportunity to address the committee about this issue. And this is an issue that, in my view, has the potential to change our history. Today, I am asking you to support an amendment to the Dormant Deposit Act to place an obligation on banks to give back property that they have been holding in safekeeping on behalf of deceased Irish citizens. Safekeeping is an issue I first became aware of in the 1990s when I worked in the Bank of Ireland Group, and I should start by readjusting or recalibrating your perception of what safekeeping actually is. If you're anything like me, when you think of safekeeping, you're immediately drawn to the image of a vault with rows of safety deposit boxes, each requiring 2 keys to open. That's not how it worked. If the year was 1907 and you had an item that you wanted to lodge for safekeeping, you'd package the item and give it to the bank manager. And it's important to note that the bank manager wouldn't be aware of what was in the package. He would simply note it on the deposit of safekeeping register, give you a receipt and place the envelope, package, box or whatever in the safe alongside all of the other items. And that's what took me by surprise when I landed in the Bank of Ireland in Rathmines in 1993 and started to question what all the envelopes, parcels and boxes were. You could tell by the shape of some, for example paintings, what was in the package, but you had no idea what was in the majority. Bank of Ireland Rathmines opened its doors in 1907 and the bank is still holding hundreds of items from that time on. And when I pointed out to the bank manager that it's entirely likely that the original customers are now deceased, his reaction was simple. My job is to keep it safe, and it's safe. And therein lies the opportunity with safekeeping. At their height, Bank of Ireland and AIB had over 700 bank branches between them, and every single one of those had a vault, and every single vault had items for safekeeping. Every city, town and borough throughout Ireland has potential beneficiaries of this property living in their communities today. But it's not just specific citizens who will benefit from a change of policy in this area. The cultural and historic richness of this property cannot be underestimated. Banks have provided safekeeping services ever since they've operated as banks, and much of the property they now hold is up to 200 years old. When you pause to consider that any item that was deposited for safekeeping was of sufficiently significant monetary or sentimental value to warrant the protection afforded by a bank, we have to assume that this property now represents a vast reservoir of our own culture and heritage today. You're probably keen to understand what types of property are held in the vaults, and I can give you a first-hand account based on my own experiences. I've seen paintings that are so large that they're held in pallets. I've seen single envelopes inscribed with the words "to be opened on my death," which could contain a last will and testament, a deed, a share certificate, or even a confession. Who knows? I've seen currency, antiques, weapons and war memorabilia. Even Charlie McCreevy speculated in the original debates on the dormant deposit legislation that banks could be holding the proceeds of bank robberies in their own safes. We must not lose sight of the fact that the majority of this property is unknown, and the knowledge that I possess comes from a small number of items that were opened in extremely concessionary circumstances or as a result of damage to the container itself. Moving on, the question turns to who owns this property now, and the legal position is very explicit. The property remains the estate of the original deposit maker. For those items that are supported by clear records, there is undoubtedly a huge effort involved in locating current beneficiaries, and I'll comment on later how this effort can be curtailed. However, in many cases, especially for older deposits, the bank records are at best vague or at worst non-existent. Legal advice would suggest that where there is no clear evidence of ownership outside of the item, it is appropriate to open the item to see if ownership can be established from the contents. And if it is not possible to establish the ownership after this exercise, then the property would vest in the state under various statutory instruments, most notably the National Monuments Act or the Succession Acts. But all of this remains irrelevant, as today there is no active appetite from the banking fraternity to address or engage with this issue, which is understandable given some of the legal exposures that this hold presents for banks. The elephant in the room in relation to this property rests in the fact that numerous estates have been settled after receiving erroneous confirmation from banks regarding the accounts they held. On the death of a client, it is routine practice for their legal representatives to establish the asset base, and in a banking context, this would take the form of a request for detail of that client's bank accounts. In many cases, the bank may not have captured the item in safekeeping, and for a bank now to reunite an item with the beneficiaries of such an estate gives rise to issues around the underpayment of capital acquisitions tax, penalties and interest. It also raises the question of proper succession, given that we are now in the realms of property being passed through numerous generations and numerous estates. Despite the legal complexities, my own research has led me to form the view that there never has been any legal impediment preventing banks from dealing with this property voluntarily. However, it is clear that there needs to be some form of legal impetus compelling banks to act. My robust view is that the most appropriate instrument to use is the Dormant Deposit Act. However, careful consideration needs to be given to the manner in which the legal obligations are introduced. I would tentatively suggest that any amendment should aim to satisfy the following three criteria. Firstly, and most importantly, we need to acknowledge that although the banks own this problem, they did not intentionally create it, and some form of amnesty needs to be granted, insulating them from action arising from their non-engagement. Number two, legal complexities are likely to be considerably more onerous for property deposited after the creation of the Irish state, and I would propose that the dormancy period of 15 years set out in the current Act be extended to 100 years in any amendment pertaining to this property. And thirdly, undoubtedly many of these deposits will transpire to hold currency and other monetary chattels such as gold bullion, Krugerrand, which is capable of being converted to currency and ultimately given back should a claim ever be made. We also need to be cognizant that much of this property will be of cultural and historical value and cannot be disposed of. The amendment should empower the state to take possession of these items. It is worth mentioning that although this property is largely safe, we are at risk of losing some, as there is evidence that Danske Bank has already moved up to 2,000 items of safekeeping out of the Irish state and potentially beyond the reach of any domestic legislation. I would like to leave you with the description of one item. This item, a chest, is held in the vault in the Bank of Ireland in College Green. It sits on a shelf alongside thousands of other items. The chest is slightly smaller than the rectangular coal bucket most of us would have had at our family homes. It has a domed roof. It has a large cast iron lock which secures a length of metal chain that wraps all sides of the chest. Rope is woven through the links of the chain and it's intermittently knotted, and there's candle wax on the knots in the rope. This item was deposited for safekeeping in the 1870s and nobody knows what it contains. Let your mind wander. You'll find it hard to convince me that whatever it contains, it won't change or perhaps mould our view of history. This isn't Pandora's box. This is our heritage boxed off. Thank you.
Thanks very much, Mr. Connolly. I now call on Mr. Kenneth Jordan, Principal at the Department of Rural and Community Development, to make his opening statement.
Chairman, thank you for the opportunity to present this opening statement on behalf of the Department of Rural and Community Development. I'm joined by my colleague, Mr. Stephen Brady, who also works with the Finance and Evaluation Unit in the Department. We've been invited here today on the topic of abandoned safety deposit boxes and the law, and we are here in the context of our role in the administration of the Dormant Accounts Fund. The Dormant Accounts Act covers accounts with banks, building societies and Post, along with certain life assurance policies. Under the Act, an account is defined as dormant when there has been no customer-initiated transactions for 15 years. If this has occurred, the institution must write to the customer, giving them until the 31st of March of the following year to reactivate the account. If the account is not reactivated, the funds are transferred from the bank or other institution to the Dormant Accounts Fund, which is managed by the NTMA. However, the legislation guarantees the right of account holders or their next of kin to reclaim the funds at any time in the future. While the funds can be reclaimed at any time, the legislation also provides for the disbursement of funds that are not likely to be reclaimed. The funds can be utilised for measures aimed at addressing social, economic and educational disadvantage or supporting people with a disability. To achieve this, the legislation provides for the production of 3-year disbursement schemes and subsequent annual action plans. The annual action plans identify the measures across government departments which are to be funded from the Dormant Accounts Fund. The responsibility for producing these disbursement schemes and annual action plans currently rests with the Minister for Rural and Community Development and is delegated to Minister of State Seán Canney. With regard to the use of money in the Dormant Accounts Fund, last year there was €28 million disbursement from the fund to support a range of measures. As previously noted, these are delivered right across government departments and they include, for example, investment in sports facilities and sports programmes, supports for carers and investment in social enterprise and social innovation. It's also worth noting the Acts require a review to be carried out on a 3-yearly basis. The Department completed and published such a review in July of 2018. The focus of that review was very much on ensuring the efficient and effective use of monies in the fund for the purposes provided for in the legislation. However, the review has also committed to carrying out research on the potential to supplement the fund from additional sources, and we will be commissioning that research as part of the implementation of the review. With regard to the total value of the Dormant Accounts Fund, at the end of 2018 there was a total of €290 million in the fund. Of this, the NTMA have set aside a reserve of €88 million, which is to ensure the availability of funds for those seeking to reclaim their money from the fund. There is also outstanding commitments to support measures of €56 million, so that is money to support measures which have already been approved by ministers. And there is therefore around €146 million remaining for use in terms of projects and programmes under future action plans. However, as the money in this fund remains the property of account holders or their next of kin, the use of money from the fund adds to government debt, and it is therefore treated in exactly the same way as any other type of government expenditure. And therefore, increasing the overall value of the fund does not necessarily mean there can be additional expenditure in any one year. Finally, just to close on the matter of direct concern today on abandoned safety deposit boxes, we have been forwarded 2 papers on this issue by the committee. The first was a paper by Jim Connolly, and the second was a legal opinion on the matter. The matters raised in both of those documents, in our view, relate mainly to issues such as ensuring registration of safety deposit boxes, ensuring their records are sufficient to be able to contact beneficial owners, and also ensuring some dating of access to these boxes. These matters relate mainly to the issue of how safety deposit boxes are regulated and how banks and other institutions should apply any such regulation. We do plan to include this as an area for specific consideration in the forthcoming research into potential additional sources of funding, and today's discussions will inform how we progress that work. However, as I have noted previously, there are significant resources within the fund at the moment, and the Department's immediate priority is to ensure the effective use of those resources within the fund. In this regard, the Department has continued to address the recommendations made in the review of July 2018. I'd be happy to assist the committee in any questions they might have.
Thanks very much, Mr. Jordan. I now call on Mr. Owen Dorgan, Principal at the Department of Finance, to make his opening statement.
I would like to thank the committee for inviting the Department to address it in relation to the matter of abandoned safety deposit boxes and the law. I am accompanied by my colleague Fidelma Cotter, and we look forward to hearing the committee's analysis of the issue. As per the committee's correspondence, the lead department in relation to the Dormant Accounts Act is the Department of Rural and Community Development, so that department will lead on any amendments to the Act. The Department of Finance will feed into possible amendments as part of the normal government decision-making process. The Department of Finance analysis is that the provision of safety deposit boxes is not at this time a regulated activity, and as such neither the Department nor the Central Bank have detailed information on these activities. Given the limited information available, the Department welcomes any analysis that the Committee can make available. To be of assistance in advance to your analysis being provided, I will briefly set out the primary rationale for financial regulation and supervision under the Central Bank Acts, which has two overarching objectives. Firstly, to protect consumers given the complexity of financial products and services and the significant informational advantages that financial service providers have compared to the average consumer. And secondly, to protect financial stability in the wider economy, given the substantial negative employment and economic impacts from financial instability events. Based on these core principles of financial regulation and supervision, it is difficult to justify the regulation of safety deposit boxes from either a financial consumer protection or financial stability standpoint, as safety deposit boxes are a very straightforward, simple product that all consumers can comprehend. Essentially, there are no significant information asymmetries in favour of the provider of the product. And secondly, the safety deposit boxes do not provide a financial stability risk, as there is no ability for the providers of the service to leverage the contents of the boxes. If they were doing so, they would fall within the definition of providing a banking service, and as such would be regulated. I suppose in the event of legislative proposals on this matter, it is likely there will be cost implications either for the state or the private sector, and as such a cost-benefit analysis must be conducted. Obviously, given the multiple competing pressures on public funds, any cost to the exchequer from proposals must be considered as part of the annual estimates process in comparison with all government social and economic programmes. If costs are to be imposed on the private sector, a clear policy and principles rationale will be required to justify legislative changes that have cost implications for that sector. It is vital that the benefit to the common good is clearly articulated and preferably quantified. I suppose, as set out in the Secretary-General's letter to the Joint Committee, there is a significant difference between dormant accounts and similar assets such as unclaimed life assurance policies and abandoned safety deposit boxes. The existence of dormant accounts in banks is generally of significant benefit to banks, as these dormant accounts offer perpetual liquidity to the bank, which is a very significant benefit, especially in periods of financial stress. Whereas the maintenance of dormant safety deposit boxes are generally a cost to banks, as they must incur the cost of maintaining the deposits for no benefit or minimal cross-selling benefit. The benefits arising to banks, as opposed to the state from dormant accounts, was a key rationale for the Dormant Accounts Act, which brought these accounts under the management of the state for use in community development projects, but also ensured repayments of the accounts if the owner or successors were subsequently identified. However, the inverse of that policy rationale would apply for a safety deposit box, which are significant costs to the holder and would also be a cost for the state if they were taken into state ownership. There are a number of additional interlinked factors that require careful consideration in relation to any proposal to bring assets in safety deposit boxes within the remit of the Dormant Accounts Fund or to make assets subject to statutory reporting. One, insufficient information. There is no comprehensive information available to the Department or the Central Bank on the possible contents of safety deposit boxes in existence throughout the banking sector or possibly the wider storage sectors. This makes it very difficult to accurately quantify the number of assets that could be covered by the extension of the Dormant Accounts Fund and the likely cost implications for the state and or private parties. 2. Protection of delicate contents. The National Archives and National Museum will be better positioned to advise on how best to open and review the contents of these boxes or the storage where they are held, given the passage of time will mean the assets will be in poor condition, maybe in poor condition. Also, the potential transfer and or cataloguing of these assets on the basis of a state instruction could cause damage, thus potentially making the state liable for any compensation. Third point is multiple asset classes. The contents of these deposit boxes could be a wide variety of assets as opposed to solely money/deposits, which is currently the asset class covered by the Dormant Accounts Act in terms of deposits and life assurance policies. The variety of assets would dramatically increase the administration costs for any extension of the Act, as the asset will likely be physical and that must be carefully handled, valued and stored, as opposed to merely deposits cash, which is a single asset class and a store of value. Also, in the event of people coming forward to claim assets, the state can always pay out deposits. However, the state sold unique assets in order to fund community development activities under the Dormant Accounts Fund. The state is unlikely to be able to subsequently replace the asset or satisfy the affected person with adequate compensation. In addition to the cost of opening the boxes, there is extensive transfer cost involved in taking control of the contents of safety deposit boxes, as opposed to a straightforward bank transfer for dormant accounts. Fourth point is transfer of liabilities to the state. As mentioned previously, the private banks are liable for the safekeeping of these deposit boxes, which at this point is most likely a loss-making activity. Any proposal that the state take over ownership will transfer the cost of keeping these assets to the state. And the fifth consideration is, in addition, there are a significant number of complex legal and constitutional considerations that others are best placed to advise on, such as the exact definition of storage that would apply, the risk of challenge to this effective confiscation of private property, adjudication of inheritance disputes, amongst others. If the committee seeks to further progress this matter, it may be worthwhile to consider alternative statutes that would allow the state to access safety deposits in order to identify and take control of assets that could be considered to be key historic artefacts. Such an approach would likely provide a stronger public interest rationale and legal basis. As stated above, the relatively limited information on safety deposit boxes makes it very difficult to conduct the necessary cost-benefit analysis. However, a high-level consideration of the above issues indicates that it is difficult to see how a proposal to make safety deposit boxes subject to the Dormant Accounts Act or a statutory cataloguing requirement would pass a full ex-ante cost-benefit analysis, given the existence of definitive costs and risks as compared to very uncertain benefits. I hope the above analysis is of assistance to the committee, and we will attempt to answer any questions that the committee may have.
Thanks very much, Mr. Dorgan. I'd like to thank all the witnesses for coming here today. It's a very interesting topic. It's an issue that was raised originally by Deputy Éamon Ó Cuív, and we've placed it on our work programme. We've had a private meeting on the issue, and we're just trying to pull everything together, get all the stakeholders around the table. So we actually have apologies from the Banking and Payments Federation of Ireland. Unfortunately, they weren't able to make it today. But this is an initial step in public session in relation to this particular issue. And it's very interesting indeed. And I'd like to thank you, Mr. Canney, for giving us an insight into, I suppose, the workings of the bank and what actually goes on in there. And I suppose it's the unknown, really, isn't it? You know, like all these hidden artefacts, you know, matters of interest, paintings, possibly gold bullion, money, you know, all this stuff is stored away in the banks, and it's trying to identify who owns that or who should be the benefactor. It's there so long as well, and as you say in your opening statement, basically the bank's job is to keep it safe. There's no obligation on the banks to actually do anything with it. And that's where we come in, because there's a window of opportunity through the dormant accounts legislation, and that falls within the Department of Rural and Community Development. So it's for that reason that this committee has taken it on. And I'd like to thank Mr. Dorgan, you know, for your insight and, you know, pointing us in a direction maybe away from that legislation. But it's something that we need to explore, and we have a legal advisor here with us today, and who has presented to us previously, and you know, she's taken note of what's going on here at the committee. But it would be our intention to possibly publish legislation around this area. So we want to get this right from the start, and that's why we've invited yourselves here today. But I'd like to just to tease out, like, there's a 15-year rule there in terms of the dormant accounts, and if there's no transactions on an account for that period, you know, it's looked at and it's absorbed into that fund. And I know the fund it's a serious fund. Like, what would you regard, and I know Mr. Canney has suggested 100 years, but what would be regarded as a reasonable time frame whereby possibly the state could benefit from those proceeds, whether it's, maybe it's a historical artefact, maybe it could be money or, whatever, where it could be sold or the value of it realised, and the state could benefit, community development could benefit, or different areas throughout the state could benefit. But what would you regard as a reasonable time frame? Maybe I'll ask Mr. Dorgan to give a view on that. I know in the state of California that safety deposits that are abandoned, they move within a 3-year period. So maybe that's a bit too quick. But what would your view be beyond that? I think a big consideration then is the cost as well. And you've outlined the pitfalls and who pays. We really do need to get the banking representative group here to the table to get their views on this, because there is a significant cost question. There is a significant legal question as well about ownership, title, all of this stuff, GDPR. It's a new consideration as well that's in the mix. But just about bearing the cost of this as well. But maybe you could take on those questions, Mr. Dorgan?
Certainly, Chair. I suppose, look, firstly, it's difficult to, I suppose, give any sort of definitive view, because this isn't, there's no specific government policy on this at the present. I think Mr. Connolly's suggestion of 100 years is quite a sensible one, given, safety deposits, could be put away for quite a considerable amount of time. It's not like a dormant account. I suppose, look, what the key issue actually, and it might be of assistance to the committee, yesterday I was speaking to the official who did the Dormant Accounts Act back in 2003, and she kind of informed me they were looking at safety deposit boxes at the time, but it just became such a legal and constitutional quagmire, they decided to omit it to progress the core legislation. I think one issue in terms of the cost, and it is an important issue, is whether or not the cost falls on the state or the banking sector. Even if it falls on the banking sector, the reality is ordinary consumers will pay, whether it's through basis points on their mortgage or not. And they're paying for the cataloguing of assets of wealth, as opposed to what is so it could be essentially a private citizen coming into wealth. Obviously, this is why I think we suggest maybe looking at from a public interest. So kind of then going back to the real challenge here is the Article 43, the protection of private property, which is allowed to be delimited for common good reasons. And that's why I think we're thinking the common good logic would most likely be for historic and national artefacts of historic national importance. Because it's very difficult to make a common good argument to do this in the interests of individual citizens who already held vast wealth that they needed to use the safety deposit boxes. So I think that's just in the cost. We're kind of eager that, obviously we're highlighting the cost to the Exchequer, but even if there's a cost in the banking system, it actually falls on ordinary consumers as opposed to those who would have wealthy assets. I don't know if that's of assistance.
Thanks, Mr. Doggett. Would you have a comment to make, Mr. Connolly?
I think there's a countless ways that you can approach this. I think that you can probably draw on some UK experience in this front. They've built an entire private sector industry around air hunters. So where estates which have nominated beneficiaries, but nobody can find the beneficiaries, they've private sector firms that locate beneficiaries, and they cover the cost so they charge the beneficiary for actually locating the individual. So I think there's ways to avoid either the state or the bank paying for this. If the appetite was to curtail costs, I think this is a bigger issue than costs. I think this goes to the root of fairness. There are citizens around, when we're talking. Unfortunately, there are no statistics. I'm putting a figure of tens of thousands, but literally tens of thousands of Irish citizens could benefit from a windfall of property that they simply don't know exists. And these mightn't be wealthy individuals. These might be individuals who are in desperate need of money. So I think the cost issue it probably deflects from the core fairness of what I'm hoping to convince the committee to adopt.
Thanks, Mr. Connolly. Would you have a view on any of those issues?
There's a couple of things strike me, just in terms of the kind of period of dormancy. Under the Dormant Account Acts and bank accounts, it is 15 years. And on average, it does vary, but on average is about 50 million comes into the fund each year. But there's another 25 million which gets reclaimed. So even at 15 years on bank accounts, there's a huge kind of turnaround of people obviously discovering they have a bank account. So I think the answer I'd be given on that one is it's definitely longer than 15 years if somebody has lost touch of their bank account, and that I think for assets it would need to be longer than that. But I think the other thing that strikes me here is, I suppose, what is the primary objective of this proposed legislation? If it's about the kind of more cultural heritage elements, I would certainly feel the Dormant Accounts Act isn't the place to achieve that. And I think with the Dormant Accounts Act as well, the idea of a windfall isn't necessarily true, in the sense that the state still needs to keep the asset there to pay the person in perpetuity or their estate. So it's not really a windfall, it's more like a kind of almost a loan reserve, if that makes sense. I'm not sure if I'm explaining this well, but even with the cash sits there, the NTMA keep a reserve to make sure they can pay people who come to get their money. And really, it's an alternative source of loaned money rather than a windfall. So I think they're the 2 points that are coming to mind in my, so I suppose, what's the key objective or the common good kind of here? And I would be feeling, having heard the 2 other inputs today, that I certainly wouldn't feel the key benefit here is a boost to the Dormant Accounts Fund. And again, even if there was some sort of rough idea of the value of these assets, because we do have significant money in the fund, there are significant inflows from bank accounts. So even just the relative scale of what inflows might be would kind of give you some impression of what the cost benefit is on this.
Thanks very much. Just bring in Mr. Connolly.
Yeah, I think that the instrument, the dormant deposit instrument, was, in my view, the catalyst to get to place an obligation on banks to address this cattle or this property that they have. I think you're right. Is that in dealing with this property, if an obligation was put on the banks to catalogue what exactly they have, I think that gives the opportunity for the state to actually examine the property and assess ownership under the National Monuments Act, for example. They don't have to use the Dormant Deposit Act to claim ownership of some of this property, but there has to be some catalyst sort of forcing these institutions to catalogue the property in the first place. And I think that I still think that dormant deposit legislation is a nice conduit to achieve even that goal.
Thanks, Mr. Connolly. I'm not going to bring in Deputy Martin Kenny.
Thank you, Chairman, and thank the witnesses for their comments, and particularly for Mr. Jim Connolly for initiating this process in the very beginning. I think it's been a great public good you've done to get this conversation to happen from the very outset. Really, just listening to it and the previous conversations we had at committee here, it strikes me that this is something that can't be just left there. We have that choice. Just leave it alone, leave it lying there, and I don't think that's appropriate. Particularly when we're looking at probably much of this property, or a certain point of it, been there 100, maybe 150, 200 years. The people who own it are probably long dead, and the issue is families out there, and I know. I spoke to somebody in the legal field recently, and usually when a solicitor, when someone passes away and they write to the banks, or they write to see what money is in the bank account, is what they ask. They don't ask, did they ever bring a parcel in with them? And normally that's overlooked, and would probably, if it's overlooked today, when we have much better record keeping than we would have had 50 years ago or 100 years ago, it certainly was overlooked then. So it's very likely that there are a large number of very valuable items. It may be in some of those boxes, maybe valuable jewellery, maybe valuable, or it may be things that were just of value to the individual. It could be a set of love letters from someone that was in India that they were receiving all their lives, and they bundled up and put into a box. And maybe it's only of value to them, but it is of historical interest and historical value. And I think that's the point that Mr. Connolly makes, I think, very clearly. the issue here about private property and about the law surrounding that is really where the tangle gets into. And that the bank has taken on a responsibility to protect the interests of that individual, that their private property is going to be held in safekeeping for them, and in effect of that for their estate, which is now really what you're doing it for. So my view is that there needs to be some mechanism put in place to move this into a space where it can be dealt with appropriately, where the bank can, and I'm quite sure the banks are, while it's there and it's sitting there and it's not probably costing them very much from the point of view that it's there in the vault and that's it, but at the same time it would be, I think, in their interests to get it moved off pitch somewhere, that it was sorted out properly. And I think the state does have an obligation around that to try and do that, and to try and come up with a solution here that works for everyone. The cost involved would probably be quite considerable, and I take the point that if some of the goods were damaged in transit or were not that somebody could sue the state for doing that and all of those. But I think we'd have to be able to, whatever legislation we put in place, would have to be able to deal with all of that. Would have to be able to look at all of those issues and be able to say, well, if the state has taken on that role, that they couldn't be sued for that, that they will be doing so in public interest and in the interest of the estate of the person who first lodged that item in place. So I think that the real issue here is, how can we legislate for this in a way that basically provides the end result? And the end result we want is that these items are taken into safekeeping, are opened and examined and decided what's going to be done with them, and that there is a clear effort made to establish the next of kin of the person who deposited them in the first place. And at that stage I expect that there will be a negotiation with them as to what will happen with the particular item. If, for instance, it was something that was of just purely of personal value to them from the point of view of, as I say, letters or documents of some kind that was of no value to the state, but it was something else that was of great value, that was perhaps an historical artefact of some kind, I imagine there would be some way that could be possibly put into the National Museum in safekeeping or whatever. So I think there is an opportunity here for to resolve this issue, but really we have to find a way of doing it that doesn't expose the state to a huge loss. But I personally don't think that's possible. I think that these people who put these items in place, if they weren't valuable items, they wouldn't have put them there in the first place. The other issue, and it was mentioned about in Britain, how there's this thing of people, air hunters and all of that sort of thing. And I just wonder in other jurisdictions what examples are in place there. Because I'm sure, like we all know, every country in the world had safety deposit boxes and had items lodged. So what has happened in other jurisdictions? What models could we find in other countries in Europe or other places that we could possibly look at as examples of good practice in respect to that? I'd also be interested just to see some of these envelopes that are left there could contain large sums of money, but that money is probably long out of date from the point of view of what happens to that? How does that work now if it's old guineas from 150 years ago? What value are they really now, or is there a way of actually making them into the value which they would be for the next of kin involved? Thank you, Chairman.
Mr. Canney, I call on Mr. Dorgan maybe to address some of those points raised.
Yeah, I suppose the first one of the points Deputy Canney made, that the banks would be eager to transfer, I think you're correct in the sense, and I think for banks it's that they want to get, they prefer to get rid of a lot of this because there is an opportunity cost of storing all of this. I think that's one of our concerns, that we don't allow the banks an easy avenue to offload the problems that come with these in terms of establishing who is the heir, successors on it, back to the state. I think in terms of the other member state models, yeah, I think it would be useful. I think the examples Mr. Connolly cited are correct, and especially in America, I think there's a very big industry of this. I think the big challenge we've always faced, and it came up in the Dormant Accounts Act back in 2001, 2002, 2003, was Article 43 is very restrictive, is viewed as being restrictive in terms of private property, because with a safety deposit box, you very consciously made a decision. This is your private property. You are putting it here for safekeeping. Whereas, you know, cash is a more, you know, it's fiduciary issue. That's the benefit of it. In terms of old money, it's a very interesting question, and I honestly don't have an answer. I don't know. You may even have to. We can contact the central bank and just see what cash they will exchange. You know, obviously they'll exchange Irish punts, but how far back will they redeem cash for? I don't know if we'd even have to go further back to the Bank of England, take over kind of liabilities that were attached to the old pre-state Bank of Ireland. We'd have to come back to you on that.
Yeah. Thanks, Mr. Dorgan. Mr. Jordan.
I mean, look, one observation, I suppose, I'm even left wondering, having followed through on the idea that you open the boxes and you find out what's in them, if the original owner or their next of kin does then seek compensation, I think there's probably then an ongoing issue around who decides on what the appropriate level of compensation is for the asset at that stage. But again, look, I think, as Owen said there, I think the idea that maybe, you know, looking at other jurisdictions and seeing what they do there is a good idea. But yeah, and look, on the old money, again, limited knowledge on this, but one would expect, obviously, inflation, no matter what the exchange, no matter how we exchange the money, the inflation is most likely completely wiped out the value of anything that was in the box for 100 years. So I don't imagine the cash deposits would have a huge value on that. But yeah.
Okay, thanks very much, Mr. Jordan. Now, Mr. Connolly.
I probably would disagree that the banks would be. I think they would be very eager to get rid of this property, but it would be very conditional. Because I think, and I'd have a genuine concern that the banks would view this property as I'm not sure what adjective to use, but explosive is probably if I cite an example, imagine that we passed legislation and the banks opened the first envelope and it was a will, and they give it back to the individual, and the individual says, well, that's no good now. Well, sure, that gave everything to my dad, who would have given everything to me, but because he didn't give me the will, the estate went in 10 different directions. So I'd have a fear that the banks may actually take a view that there's nothing in it for them, and it's possible that a decision would be made to destroy the items. For fear of what might be unearthed. So I think that the idea of an amnesty, and to recognise that the banks will only engage with this if you give them a clear comfort that they're not going to suffer legally as a result, so that people cannot go after them for their non-activity. So I think whatever we do, I think the banks have to be insulated in some way, shape, or form. As regards the currency piece, there is a point where the central bank will exchange currency, but you have to measure that up against if it is guineas, they might actually be worth more, you know, for historically than there would be monetary value. So you actually could get more for them in an auction than you would give to the central bank. So there's a bit of a how long is a piece of string to that question, but it's a great observation.
Thanks very much, Mr. Connolly. I'm now going to call on Deputy Éamon Ó Cuív, and Deputy Ó Cuív is the individual, the member of this committee that actually raised this issue, and you know, thankful.
I seem to get unlucky every day that there's a committee here with something very interesting. There's also questions on the dial that have relevance with, and it's hard to be in two places at one time. My thinking on this is, first of all, when we look at the current dormant accounts, the obligation, first of all, is to find the owner. And it's only in the event of the bank not being able to find the owner there's any question of it being transferred. And the second principle that's always been there is the money always belongs to you if you do turn up. In fact, to the point of, my view, nonsense, in that the state sees all of the dormant account money that has ever been handed over to the state as a current liability. Two chances of that, none and none. That everybody that ever created a dormant account, in fact, the amazing thing that surprises me every year is the net inflow is about 20 million. That's net, that's reclaimed versus money coming in. And therefore, there's no chances of all the people ever turning up to claim their money. But we're not here to discuss termed accounts, but there are two principles there I think are of relevance. Now, the next item here is that my understanding is that deposit boxes go back to the beginning of the 19th century. Now, if it's money and you know who owns it, well, you know what you do with it. You give it back to whoever it is if you open it up. That's black and white. Same principle as with anything else. If it's goods and you know who belongs it, it's their goods. So if you know who the inheritor. Now, we can take one thing for certain. If we opened every box between now and 1900, from 1800 to 1900, there ain't going to be anybody alive who put it in. That's 100% certainty. So you're actually talking about heirs and descendants, and probably descendants at a fair degree at this stage. Now, allowing that you can match it up, then they get their property back. They mightn't want to leave it in the deposit box, but they mightn't realise it's there. Now, the thinking I would have on this is that you would decide the same principles that we've used in other things. For example, if an artefact is found that's over a certain age, the state is claiming it anyway. So if I find a golden chalice on my land, unfortunately I don't get to own it. Because at a certain age, even though I bought the land and everything in the land, I don't actually, despite what I thought, I don't actually own everything in the land depending on what is found under the land or in the property. So that principle is well established. Now, the next issue, as I would see it, is that if you start at 1800 and you stopped at 1900, the issue of privacy, well, we've already published for 1911 census. Now, there was a question then when people want us to move forward faster in terms of people being alive if you move, who are mentioned on censuses and so on. But we have decided that even though census documents are totally confidential, that they can be made public, and we have made them public up to 1911. And we've all found our own relatives there and all sorts of interesting facts we didn't know. We found in our family an interesting one. Seán Ó Cuív, my grandfather, actually filled it up in Irish, but in the spelling that relates to the name C-O-I-V, absolutely phonetically in his simplified Irish. So he really carried that to the nth degree. Now, let's presume you go in and you open every box starting at 1800, 1801, 1802, 3, 4, 5, and you keep working forward. If you find money and you find the owner, give it back. If you find articles and you find the owner, give them back. Now, let's supposing you find very, very interesting artefacts that would be akin to what you'd find in museums or whatever, and that don't compromise anybody or anybody's family. The thinking I would have is that they would be lent to the state and put on display, but they would still belong to the owner if the owner ever turned up. So in that case, you're not actually transferring ownership, you're just putting them on display. So you're taking a little bit of liberty with the property, but you're not transferring the ownership. And if you go into Kilmainham or any of these, you find an endless amount of artefacts on permanent loan. And they don't have to be owned. So would I be interested in finding out from you that allowing you did it, so you decide not to do anything current, anything, in fact, you'll be a long time before you get to 1900, I suspect. So, and when you got to 1900, you could see how you're going, what issues had arisen. So by putting back into the very distant past, and only putting in things of national interest on display, and only putting them on display but not transferring ownership, saying that on permanent display, these are belong to box. If you are the owner, come and collect, stake your claim. Would that pose a huge problem? Now, it seems to me also that if you were covered by legislation, that there would be a lot of good for the state. There could be very, very interesting documents are artefacts there that would be very, very interesting historically, that would give a much wider understanding of our history, and would show probably some quite beautiful things that have been hidden away. For all we know, there's a Caravaggio there, or some other, a Rubin or something else there. And enough pity not to have it on display. And as I say, owners come and collect if you can prove your ownership. So allowing that that's the way you do it, and you wouldn't suddenly start opening up deposit boxes of much more recent vintage and make them public display, and that you had a committee set up who would adjudicate as to whether it followed, certain standards were followed and criteria followed on the items you put in display. What would be the problems, or would you foresee problems in that case, allowing that you legislated for it? Now, the other thing that I think we should keep in mind, I had heard this Article 43 one all my life in politics. I could never understand the interpretation that was imputed by the courts to have been put on Article 43 in terms of private ownership. Because it always seemed to me that the right to private ownership was being taken as absolute, whereas the Constitution is quite clear, it's subject to the exigencies of the common good. And I always remember when we had to make decisions in this House, curtailing rights to property, etc., in terms of wages and pensions or whatever, during the last financial crisis. And if you look at the legislation, what was said was, look, yes, there's a right to private ownership, but it's not absolute, and it can be curtailed if it's outweighed by the common good. Now, by not transferring the ownership and only using on a loan and doing that very judiciously, I often wonder what real challenge could arise. Because if you did turn up something turned up, we say, I think in one of the documentation said, Jim, you mentioned a jewelled sword. Now, supposing a jewelled sword turns up, right, and you put it on display, something valuable, something very interesting, Crimean War or whatever, dress sword, or Battle of Waterloo, or award for gallantry or something. Now, supposing then the family of the family of the family turn up and say, well, by the way, we can prove that's ours. Now, what complaint could they have? Because they were never going to find out it was there in the first place. So I think we've become paranoid in this state about challenges. And I take the view that we took as a House in 2010, that you weigh up the balances and say if somebody wants to challenge, fine, but it's very unlikely. It was proven in 2010 to be very unlikely. It didn't happen. And I think we would, if we constructed this rightly, it would prove unlikely in this case as well. So what I'm saying is principles are, don't transfer ownership of any artefacts because you can't replace them, but just put them on display, straight display. Second thing, start at the oldest ones first and work your way forward. So nobody alive is going to be affected one way or the other. And the depositor can never come back and say, I deposit that on the basis that it would never be open because they ain't existing anymore. And three, obviously, if you find the owner, they get it immediately. If you can't find the owner and they subsequently turn up because you put it on display, they get it. Which means that, in fact, it has been an advantage to them, not a disadvantage to their property rights, because they actually get the property that they wouldn't have even known existed. I'd be wondering, and that leaves the one question that seems to worry the banks. I thought banks were full of money. But anyway, they're worried about the cost of all of this. Again, I think if you do this judiciously and carefully, it mightn't be that much of a cost. And if there's a cost to either the state or the banks, I think that's something you work out as you go along. But, you know, there is a thing as corporate responsibility, and agencies spend a lot of money on corporate responsibility and goodwill and all that kind of thing, and advertising and sponsoring sports and sponsoring this kind of thing. I think that particularly the older banks with the older deposits could actually get an awful lot of goodwill by doing this if it's done properly.
Thanks, LP.
So my question is, like, if you construct it that way, can I just say, I think there's a separate issue that has nothing to do with today's debate, and we can put it totally aside, and that is the regulation of safe deposit boxes from now on in, because that's become a private industry, and that is another issue. People who go to these private industrials are going to non-regulated entities. That's a different thing, and it's an interesting question since it's moved away from the banks. How safe are all these deposit houses? I don't know, but I don't think that's nothing to do with where we're at, so we can leave that to the Finance Committee to look at. It's not our baby.
Thanks, Deputy Ó Cuív. And that begs the question, who is responsible for that regulation in that regard? Mr. Duggan, could you please address the issues raised?
Just actually following on from Deputy Ó Cuív's point about corporate and social responsibility, it was always emphasised through the Dormant Accounts Fund debates that there is personal responsibility as well, in terms of, if people are fortunate enough to have significant assets, they should be thinking of how to ensure their properly will, their proper set out what the assets are, and that they do flow to their successors or their inheritors. In relation to the point about the private property argument, I suppose just the point we were making was it's difficult to obviously Article 43(2) says you can delimit it for the common good, and I think the point you're making is exactly right. The common good is the historic and national importance of these artefacts. The point I was making earlier on, it's more difficult to justify these on a common good basis if one individual gets an asset of wealth because the state has taken an action. It's more difficult to justify that as a common good argument, and that's why I think the point you're making in terms of looking at this from a historic and cultural aspect is actually a strong basis for allowing some exercise to take place. The point we're also making is just the cost. There will be a cost, and the reality is either it falls on the exchequer or the private sector, and the reality is, though, if it falls on the private sector, it will fall on ordinary bank customers eventually. It won't be the people who will benefit from these assets if they were to go back to private ownership. And then I think just the point you made, Deputy, about the government accounting rules, about the, you're correct, I think Mr. Jordan was outlining earlier on about how essentially 50% of these dormant accounts funds end up going back, but there is a net 25 million. I suppose the way we have to account for them, it just is standard government accounting rules. We all probably know it's highly unlikely that ever be called upon, but
I would dispute that. Because I had this argument before with various Ministers of Finance. This idea of saying everything is a liability, right? Yeah. The central bank, who aren't here today, have a habit every now and again of writing off, well, they used in the old days with their own currency, I don't know if they still do it with the euro currency, writing off non-return currency that theoretically could be out there somewhere and all reclaimed. But every now and again they'd come in and there'd be a windfall in the government balance sheet by the central bank saying, like, there's so many notes and so many coins gone missing that will probably never turn up.
Yeah. I think it's the Eurostat rules would apply for both those cases.
But what I'm saying is, in the old days they were able. Yeah, but there's no constitutional difficulty here.
Oh no, it's sorry, just in terms of how it's accounted for as a contingent liability on the state would be under Eurostat, the ESA rules.
Well, if European rules are that stupid, it's time we change them. I mean, sometimes I wonder, have we come to the point of living in the real world at all? But we won't go to that element of dormant accounts. But it is so ridiculous. But you could say that everything is a liability. But a liability, I mean, I'm probably diverting here slightly, but the chairman can be indulgent. My view always was that you would say that anybody who wants their money back will get it back. And unlimited, right? But they get it back in the following order, as they do at the moment from this year's inflows. Right? And number two, if that wasn't sufficient, which is about 1 million to 1 chance in any 1 year, they get it out of the statutory reserve that's already there. And if that weren't sufficient, they get it out of the money on hand that the dormant account inevitably always has. And if that wasn't sufficient, rather than saying they get it by the state having this contingent, that they get it out of the next bob that will come in, which would be. Now, I'd love to go down on Paddy Power and put a bet that you'd ever get that far in your contingent. Therefore, it's a bit of a codology of government accounting. And if your staff rules are that stupid, it reduces my belief in their intelligence dramatically here this morning.
Thanks, Deputy. Do you have a further comment to make, Mr. Dorgan?
No, I think I covered all.
Thanks. I'll bring in Mr. Jordan, please.
I mean, look, I think we said in our opening statement as well, I think a lot of these issues are really more around the legal regulation of these, and I think our own department couldn't really offer any views. They'd be opinions rather than anything. And again, look, we are responsible for the Dormant Accounts Acts, and it is the inflows and outflows are, as the Deputy said, is kind of 50 million on average comes in and 25 million on average goes out, so there's a net gain. But I just glanced there at the back, and since it has been set up, there's 380 million has been reclaimed since 2003. So there are significant reclaims.
And that's in a very short time frame. I mean, it's 15 years when it becomes dormant.
Yeah.
So that's in all of our living memory, and most of the people whose money's going dormant are still alive, right? So obviously you're going to get large reclaims, but what always amazes me is that the inflows are twice.
Inflows, yeah.
And who do you think should be responsible for regulation, Mr. Jordan, in your own view?
In my own view, can I have my own view? I'm not sure.
Yes.
God, I honestly no, I can't answer. I mean, look, it would seem. I mean, again, I think I said at the very start after your own comments. To me, it's what's the objective. If the objective is about heritage and culture, and I mean, I view, I suppose, that's possibly where it is. Again, back to, if the objective is about raising money, that's a different issue. If the objective is banking regulation, which I think Deputy Ó Cuív said it's not, that lies elsewhere. So I think it is just back to what's the core thing trying to be achieved here. Yeah.
Okay, Mr. Connolly, going to bring you in there to respond to Deputy Ó Cuív.
Yeah, I have to congratulate Deputy Ó Cuív. He brings an eloquent simplicity to this whole issue, and the way you articulate the manner the issue in question. I think Article 40.3 comes up a lot on this. I did take advice on it, and it would suggest that somebody's right to privacy is a personal right and isn't actionable after somebody's death. So I think that is a red herring. I totally agree with everything Deputy Ó Cuív has said. I can give you a bit of colour on the sword that he mentioned, if you like, because that's a very interesting story in its own right. Because I actually, my engagement with Bank of Ireland was actually in a professional manner, not when I was actually working there, but I created a television programme that never saw the light of day, but it was based on safekeeping, and I was given a tour around the vault in College Green. One of the items that I'd asked was, are any of these items ever opened? And I was pointed to this chest, which is about something like you'd see on the back of the Titanic. You know, it's like a chest with a big belt in the middle of it. And this item was deposited for safekeeping in the turn of the 20th century. It was 1905, to the best of my knowledge, when it was deposited. I was there in 2003 maybe, but I was told that it was opened in 1995, and that's when President Clinton came to Ireland, and he addressed the nation from College Green, and the American Secret Service, as well as, you know, welding shut all the manholes and getting rid of all the bins around College Green. They also sent the American Secret Service into the vaults, which would have been directly below where President Clinton was addressing the nation. And a sniffer dog took issue with this chest that had been there for the guts of 90 years. So they, as a courtesy to the American Secret Service, they opened it, and inside was war memorabilia, including a ceremonial sword with a jewel-encrusted butt, but also had a loaded pistol, and it was the gunpowder in the loaded pistol that the dog had picked up on. But that just gives you a flavour for I suppose the history of the richness of the history that this stuff represents. But I think the idea of going back to the oldest one and dealing with this is an elephant that I think that can be eaten one bite at a time, and the easiest way to go about it would be go back to the earliest one and move forward.
Thanks, Mr. Connolly. Deputy Ó Cuív, do you want to come back in?
No, just in relation to who does it. I suppose there's an easy answer on that. I presume the Department would agree with this. The Oireachtas does it. Now, who sponsors the bill? That's up to. If it's for a government bill, it would be a government decision to decide. Would it be arts, culture, and the way we're looking at this, or rural and community? Of course, if you had the old Department of Community, Rural and Grassroots Affairs, where you had, if you had, as it was before, in arts and culture and things were together, and Dormant accounts were together, you wouldn't have this problem. But, government all the time has to just decide, look, it's that department does the sponsoring and consults with the other departments. That's only kind of technical stuff. I think it would be much better to put it in with the Dormant accounts legislation, but that's only a personal view. If someone decides otherwise, I'm happy. But basically what you were doing is giving back to the people what they were owned, and it was only if you couldn't find the people and there were interesting artefacts would you then decide on a case-by-case basis to put them on display rather than leave them mouldering for another 1,000 years. And like, if you think of this in the long term, supposing we were on another 500 years, so they were, instead of being there, some of the things for over 200 years now, there were 600 or 700 years, right? Would anybody think it was right to leave really interesting, valuable stuff that long? No, of course they would. On the privacy issue, I think the privacy issue is total non-issue because we opened the census. And that was a much more immediate, it's 1911, and that's been open, what, 10, 15 years? So that's equivalent to 1921 now, right? And I think there were some people who weren't over happy. We certainly didn't go forward with that rapidly because but you were talking about much more immediate there than the kind of thing I'm talking about. And as I said, when you got to 1860 and 1870 and 1880, if there were issues arising you hadn't foreseen, you just deal with them. And the other thing is, would you agree that if you were going to put things in display, you'd have to have a committee who would decide what was appropriate along criteria of sensitivity, national interest and so on, so it wouldn't be just throw everything up on the table, that there would actually be a committee who would oversee this. Do any of you think that if it was done like that, that would ameliorate some of your concerns?
Mr. Duggan?
I think all we have to go on is the previous advice from 2002 and 3 on the private property issue. And it is spelled out, it's the right of private ownership or the general right to transfer, bequeath and inherit property. So it is quite specific.
And how are you interfering with that in my proposal?
I think your proposal is actually probably the right way in terms of you're doing it for saying you're taking the Article 43(2) and you're delimiting it for the interests, delimited by law the exercise, reconciling the exercise with the exigency of the common good, which you're clearly defining as the public interest of displaying these artefacts. Yeah. So I think, no, I don't disagree with you.
Like, you then raised an issue about, well, if the state spends money and you suddenly find you had an inheritance you didn't know about, and you get a big benefit, that might in some way impinge. But I don't get that logic, because the state spends lots of money trying to help us. Yeah,
sorry, it's not. That was more when we were discussing earlier on. There was a much wider interpretation that this should be about giving all of the artefacts back to, or all of the things back to the beneficial owners, and that's. Sorry, that was the point I was making. It wasn't in relation to the response.
Well, I mean, my personal view is, having over the years had now it's nearly been resolved with the unenviable task of helping people who had great-grandparents and grandparents who hadn't gone beyond that in registering land, and trying to help people who are going to solicitors and all the rest. It was always a legal problem, but people come and you had to tell them there is no quick way here, right, to establish, except to get every relative who might have an equal claim to you. Now, that's difficult when you're talking about grandparents and great-grandparents. I actually think that the chances on the early boxes here of anybody being able to establish ownership is very, very, very slight. But if there was somebody that lucky that there was a clear succession of wills that they were able to produce, good luck to them. And I think that would be just incidental luck, like winning the lottery.
Do you have further comments, Mr. O'Donnell? Mr. Canney, just to maybe to wrap up.
Probably one thing that occurred to me that probably has escaped the debate so far, but in a huge percentage of this property, the bank's records are so incomplete that ownership is unestablishable. So the bank don't know who dropped it in, and they've no records to support it, and there's no evidence potentially in the item as to who might own it. So I think a huge amount of the property is going to be deemed lost property, and I think that we need to be cognizant of that as well. But apart from that, I think this debate has been really useful, and I'd like to thank you, Mr. Chairman, for the opportunity to share my thoughts on it, and particularly to Deputy O'Cuív for his support on this. I'll remain available to the committee at any stage to fill in any blanks that they have, or add colour where it's necessary. But I really do appreciate the profile that this has been given today. So thank you.
Thanks very much, Mr. Connolly, and I want to express my thanks to you on behalf of the committee for putting forward a very strong case for regulation, reform, a look at this particularly interesting area. There's no regulation, there's no law, there's no obligation on the financial institutions to do anything in this area. And as you say, the bank's records are incomplete themselves, and a good starting point would be an obligation on the banks to catalogue the issues that are there. Deputy O'Cuív has put forward a very strong, robust, logical process whereby this issue could be tackled. Obviously, there are challenges. Article 43 keeps popping its head up there. There's legal complexities here. But certainly, it is an issue that this committee have discussed before, and we will publish a report on this whole issue, including an analysis of the current position, and we will outline the steps as well. We will continue to stay in contact with you, Mr. Connolly. The committee will also consult our legal staff with a view to drafting a bill which will address the gap that's there in the law covering abandoned safety deposits. So I'd like to thank you again, and thank the other witnesses for being here today and for your insight. Thanks very much. So it's proposed that the meeting be suspended for a few moments, allowing the witnesses to leave, and that we will resume in private session. Is that okay? Agreed?